excuse me, 253654 SM Appearances Council.
Joanne Carey for the people.
Haven O'Mara for Mr. Olvera.
And we are here for a pretrial conference. Is there any resolution?
My understanding, the defendant will plead guilty as charged, and there's an agreement for him to be treated under 4A.
All right, Ms. O'Mara.
That's my understanding.
Mr. Olvera, have you heard what the attorneys have said the resolution in this case is?
Yeah,
And is that how you wish to resolve it?
yes, Your Honor.
Will you please raise your right hand? Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right. It's my understanding that you'll be pleading guilty as charged to domestic violence. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $500. Additionally, consecutive sentencing could apply if I happen to place of confinement. It is also my understanding that you have what's called a Killebrew agreement. Killebrew just references a appellate case. But what that says is that you have an agreement with the prosecuting attorney that you will be sentenced under what's commonly referred to as 4A. That references a statute. And what that says is if I put you on a period of probation, if you're successful with that period of probation, the charge would not enter and it would be removed from your public record. It would still show on law enforcement record. Now, if you don't complete probation successfully, that charge would then enter as a guilty conviction on your public record. Do you understand that?
Yes, sir.
Now, do you also understand that that is an agreement you have with the prosecuting attorney and not an agreement you have with me? So if I don't decide that I'm not going to follow that agreement, you would be able to withdraw your plea. Do you understand that?
Yes, sir.
Knowing all that, do you still wish to proceed as planned?
Yes, Your Honor.
All right. Back on August 8th of this year, excuse me, were you on probation or parole?
No.
Were you on bond? Do you remember reading and signing this advice and rights form, talk about your rights to an attorney and your rights to a trial?
Yes, Your Honor.
Did you understand those rights?
No.
Most importantly, do you understand that by entering a guilty plea today, you'll be giving up the right to have a trial and you won't have a trial of any kind? Other than the plea agreement, has anybody promised you anything?
No.
Has anybody threatened you in any way?
No.
And is it your own free choice to plead today?
Yes, Your Honor.
Are counsel aware of any other promises, threats, or inducements not made part of the record?
I'm not.
No, Your Honor.
Then, Mr. Olvera, to the allegation that on or about August 8th, 2025 in Springville Township of Wexford County, how do you plead to domestic violence against a Sandra Olvera?
Guilty.
In order to accept that plea, I must have you tell me what it is that makes you guilty. So what happened back on August 8th?
I got into an argument with my mother, what I remember of the evening, and I put my hands on her. And that's what led to this, to everything that we're dealing with today.
Now, you say you put your hands on her. What do you mean by that?
From what I can recall, I struck her.
And where did you strike her at?
I believe it was in this general area.
The forehead?
Yes,
And was that open or closed fist?
I do not recall, Your Honor.
It's going to sound like a crazy question, but did she ask to be struck in the forehead?
No,
And so what was happening this day or night?
I was intoxicated that evening. We had an argument that was just verbal, and it escalated.
Do you live with your mother?
Yes, sir.
And is that in Springville Township?
Yes,
Now, you say as far as you recall, or as far as you remember, what you described to me today, is that your actual memory?
yeah,
You actually remember striking your mother in the
Yes.
forehead? All right. Do counsel believe that the defendants provided the factual basis to accept the plea and the court rules have been complied with?
I do.
Yes, Your Honor.
As does the court. I find the plea is knowing, voluntary, and accurate. As such, Mr. Olvera, I don't find you guilty of domestic violence yet, but I'm going to take the plea under advisement because I am going to follow the agreement and sentence you under 4A. I find that 4A is appropriate. You do not have any prior criminal record at all. While I don't know if this is a one-time event, and I guess I might be getting the cart in front of the horse, Ms. Carey, is there any, can we sentence today?
Well, that's a good question. I do have a victim impact form returned, and she did want to be notified. So I think not, although she has stated what she wants to see happen,
But she did ask to be notified.
but she did ask to be notified.
All right. Mr. Ovala, as I said, I got the cart in front of the horse. I expressed my intent to sentence you under 4A, but your mother, as the victim in this case, the Crime Victim Rights Act gives her certain rights when it comes to criminal cases. And one of those is that she has the right to be present at sentencing and address the court if she chooses to do that. She's notified Ms. Carey's office of her intent to request notification. So we are going to have to give her notice. So while we have taken the plea under advisement, we'll have to come back for sentencing. Okay. Just a reminder that you are still on bond and your bond conditions continue. You can go out to the front window where you checked in and get your next court date.
Thank you, John.
Your Honor, may I address one aspect of bond quickly?
Sure. Well, Ms. Carey, any objection?
Just to no contact.
No objection.
Go ahead.
Your Honor, now I respect that we're waiting for a victim impact statement, but I believe Ms. Carey said she already had indication what was or what his mother intended to happen. That being said, I don't think there's an issue with the no. I think there's no more necessity for the no contact order between him and his mother. They would like to be able to communicate with each other once more.
Have you had any contact with his mother in that regard?
I have not, but I am expressing my belief based on what I've been told. So, told by the defendant, it's not.
How? Okay, I'm not going to ask a
No,
question
no,
because I
he's
don't
not
want to.
talked to her.
Okay, all right, fair enough. Ms. Carey?
Well, this always puts the people in a predicament. I mean, in a 4A, and frankly, the police report does not read well. It sounds like this is an ongoing issue that occurs frequently with him getting drunk and then becoming verbally, physically abusive. However, saying that, the victim did express a desire to have him attend a family birthday party, I believe, next weekend. So I frankly am not in favor. I'm never in favor of lifting those when the case is not completely resolved or sentenced. So I will leave it to the court.
That's in her impact statement that she wants him to attend a birthday?
She called
Okay,
our office on the 25th.
but nothing about lifting the no contact order in general.
In general, no. Only
Well, I believe it's appropriate for the court to at least consider the wishes of the victim in these types of cases. And given that she is not here today, all I know is that she wishes to have the no contact order lifted for one day to attend a birthday party. So, and the court is not inclined to do bits and pieces of no contact orders. So until I know more about the case and actually hear from the victim, or at least give her the opportunity to address the no contact order will remain in place.
Thank you.
Thank you. All right, we'll go back on the people of the state of Michigan versus Burl Williamson. All right, we are back on the record in case number 253655 SD. Mr. Hartel, you had a little recess there. Are we still proceeding as planned?
Only on the bond violation portion, Your Honor. My client would wish to accept the people's offer on the underlying charge.
All right. Then Ms. Carey, it looks like based on the sheet that was turned in today, the underlying charge is up, I'm sorry, the plea offer is operating while intoxicated and the people dismiss the high back.
Correct.
All right. It's just a moment to get that sheet done. In the meantime, we can run the hearing. Ms. Carey, your first witness.
We'll call Alex Mansky.
Ms. Matsky, will you come forward, please? Sorry. Please raise your right hand. Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Go ahead and have a seat. Ms. Carey, whenever you're ready.
State your full name for the record.
Alex Mansky,
What is your occupation?
Senior Wexford County Community Corrections Officer.
Were you assigned to supervise Burl Williamson while he was on bond?
Yes.
As part of his bond conditions, he ordered to take alcohol testing.
Yes.
How often initially?
It was random, so 1 to 3 times per week.
When was he placed on bond?
August 11th is when he enrolled.
Was he ordered to take an alcohol test on August 16th of this year?
He was.
Did he take a test on August 16th?
He did not appear to test.
As part of his bond conditions, was he ordered to take a drug test?
It would be a drug and alcohol test.
Drug and alcohol. Did he take the drug test on August 16th?
He did not.
Was he ordered to take a drug test on August 16th?
He was.
Did you hear? Was he ordered then in for an ETG test after failing to take the original test?
Yes, the order, it was one order that he was to come in
Okay,
for both tests.
for both tests, and he did not.
Correct.
When is the next, after the 16th, when was he ordered the test next?
August 19th.
Test on August 19th,
He did.
and what was the result of that test?
It was negative for everything.
Then was he ordered again to test on August 21st?
He was ordered on the 20th.
On the 20th? Did he appear on the 20th?
He did.
What was the result of that test?
It was positive for alcohol, negative for everything else.
What type of test was that on the 20th?
There was a 5-panel drug test and a alcohol test at ETG.
Was that a urine test?
It is.
Was that urine, was that test verified, or was there a second test done?
There, the initial test is there's a cutoff level of 500 nanograms, and then we did a second one with a cutoff level of 300 nanograms. Both were positive. We did send it to the lab. We don't have results from that lab test.
But both of the tests that you did were positive.
Correct.
Thank you. I don't have anything further.
Mr. Hartel?
Just a few. Ms. Matsky, on the August 16th date, did my client contact you or anyone in your office in regards to that mistest?
I do not have any notes regarding that, no.
No further questions. Thank you.
Ms. Carey?
Thank you. Ms. Mansky, if the defendant had, for the record, do you recognize Mr. Williamson?
I do.
Is he in the courtroom?
He is.
What's he wearing?
He's in a flannel shirt.
Sitting to my right.
Correct.
Your Honor, may the record reflect she's identified the defendant.
Mr. Hartel?
I have no objection to that. No.
It shall so reflect.
If the defendant had contacted your office, would there be a note?
There would be.
Thank you.
Mr. Hartel?
I apologize, Your Honor. I brought up my client. Was there a question?
Do you wish to recross?
I do not know that.
May this witness step down?
She may.
Thank you, Ms. Maskey. Yes, you may. Ms. Carrie, any additional witnesses?
No, thank you.
Argument? I'm sorry, Mr. Hartel.
I appreciate that, Your Honor. My client has chosen to enact his Fifth Amendment rights. I have no further questions.
Argument, Ms. Carrie?
Thank you. The people would ask that you find them guilty of the bond violation for failing to test on the 16th as ordered, pursuant to Ms. Maskey's testimony, and guilty of a positive alcohol test on the 20th after 2 tests given, again, pursuant to her testimony. Thank you.
Mr. Hartel?
Your Honor, we do, of course, respect there's a lower burden of proof in these type of cases. My client has enacted his Fifth Amendment rights. The court does, of course, have to go on the evidence that was presented. I know Ms. Maskey testified to what she did and did not know. Obviously, we don't know if anybody did contact her office that wouldn't be in her notes, but that wouldn't necessarily be the difference in your decision, obviously. We trust the court's discretion.
Thank you. Based on the testimony they received by Ms. Maskey, the court does find that the defendant violated his bond by failing to appear for a test on August 16th, 2025, by failing to appear for a test on for an alcohol test on August 16th and a drug test on August 16th, and for testing positive on August 20th for alcohol. Ms. Maskey testified that the defendant was to do both a drug test and alcohol test on August 16th, and he was a no-show, and that 2 tests with different cutoff levels, urine tests were given to him on August 20th, and both showed positive for alcohol. I understand they are waiting for the lab test to come back, but based on what the court heard today, I believe that is sufficient evidence to find the defendant guilty for bond violations. We will come back as to what to do with that after we take a plea to the underlying offense. Mr. Williamson, have you heard what the attorneys have said the resolution is in this case? And is that how you wish to resolve it?
Yes.
Will you please raise your right hand? You solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth? You may put your hand down. It's my understanding that you will be pleading guilty to count number 2 of operating while intoxicated. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $100 to $500 and or 360 hours community service, rehabilitative programs, vehicle mobilization is mandatory with a prior, and reimbursements for the cost of prosecution and governmental expenses. In exchange for that, the people dismissing count number 1 of operating with a high BAC or bodily alcohol content, that is a misdemeanor punishable by up to 180 days in jail and or a fine of $200 to $700 and or 360 hours of community service, rehabilitative programs, vehicle mobilization with a prior, and costs of prosecution and reimbursement for governmental expenses. Is that your understanding of the agreement?
Yes, sir.
Now, if this case were go to trial, the prosecution could not move forward on trial on both counts. It would have to choose one or the other. Do you understand that?
Yes, sir.
And does that have any impact on your decision today?
No, sir.
All right. Back on August 9th of this year, were you on probation or parole?
No, sir.
Were you on bond? Do you remember reading and signing this advice of rights form, talk about your rights to an attorney and your rights to a trial?
Yes, sir.
Did you understand those rights?
Yes, sir.
Most importantly, do you understand that by entering a guilty plea today, you won't have a trial of any kind and you'll be giving up that right to have a trial?
Yes, sir.
Other than the agreement, has anybody promised you anything?
No, sir.
Has anybody threatened you in any way?
No, sir.
And is your own free choice to plea today?
Yes, sir.
Are counsel aware of any other promises, threats, or inducements not made part of the record?
I'm not.
No, Your Honor.
Then Mr. Williamson, to the allegation that on or about August 9th, 2025 in Springville Township of Wexford County, how do you plead to operating a motor vehicle while intoxicated?
Guilty.
In order to accept that plea, I must have you tell me what it is that makes you guilty. So back on August 9th, were you in Springville Township
Yes, sir.
and were you operating the motor vehicle?
Yes, sir.
Prior to operating the motor vehicle, had you consumed alcohol?
Quite a bit the night before.
Do you remember what you were drinking?
Beer.
Do you know how much you drank?
And quite a bit.
All right. And did you have law enforcement interaction?
Yes, sir.
Do you know why they pulled you over?
I was told that some people called all that was 80% away.
Ms. Carey, do we have chemical tests to support the plea?
Oxalizer test at 0.195 and a 0.194.
We would stipulate to that, yes, Your Honor.
Do counsel believe the defendants provided the factual basis to accept the plea and the court rules have been complied with?
Yes, Your Honor.
Yes.
As does the court, I find the plea is voluntary and accurate and knowingly. Mr. Williamson, I find you guilty of operating while intoxicated pursuant to the plea agreement. The operating with a high BAC will be dismissed. Do we need to set this over for sentencing?
Your Honor, I did forward an assessment just a moment ago. I don't know if the court's had a chance to receive that.
We have not received it yet, so we will set this matter for sentencing. And that brings us to the bond violation and what we do with bonds. Mr. Hartel?
Yes, Your Honor. I would ask the court to consider continuing bond. I do realize there was a finding just a moment ago. For what it is worth, my client, to my knowledge, has done well, while given the opportunity to be on bond pending resolution of that bond violation allegation. Other than the findings that have been made, I don't believe there's been any other allegations of any additional bond violations. And he certainly is taking the situation very seriously. I don't want to go into too much over allocution about that, but he definitely is highly motivated to see this all the way through properly. Thank you.
Ms. Carey?
I would argue that he did not do well on bond. He failed the test on the 16th. He had a positive alcohol test on the 20th. He was late enrolling in SilverLink on the 21st. When I look at this, I do have an out-of-state lien, and it looks like there's a warrant for OWI in 2017.
It's an outstanding warrant.
But that's what it looks like. So I did have a chance to look at the assessment briefly, and frankly, I questioned the results of that, given what the history, but there's some consequence.
It looks like I just received the assessment, so give me a minute to take a look at that. All right, I've had the opportunity to review the assessment. Any objection to sentencing, Ms. Carey?
No,
Is there any corrections to the assessment, Mr. Hartel or Ms. Carey?
Not on behalf of the defense, no, Your Honor.
was there any mention of the Kentucky issue?
There was not. There is, he does report some prior paraphernalia, possession of marijuana, public intoxication, or drunken disorder. What I see missing from that was an 05 resist law enforcement, an 05 false informing, and 20 a driving while license suspended. And I don't have my copy of lien, so I don't know if that warrant, what that warrant actually is. Allocution, Mr. Hartel?
Yes, thank you, Your Honor. I would ask the court to consider probation in this situation. I do, again, realize and respect there was a finding of guilt on bond violations. But I truly do believe my client is motivated to do well on probation if given that opportunity. Yes, he does have a bit of a storied past, and we're not denying that. But he, again, is highly motivated, and I've made it extremely clear with him that if he was given the opportunity to have probation, the violations of probation would result in potentially even more jail in the core sense up front. Obviously, there is statutory maxes on how much the court can do with things of that nature. But I know even just the concern of having the bond violation hearings today, he was very aware of the situation. And I won't go too much into attorney-client detail or anything too embarrassing for him, but just so the court knows, he's very aware of the weight of the situation.
Thank you. When I read the assessment, and it came back as a mild, I just don't think it had, I don't think they had full information. So I question that, given that he started using both alcohol and marijuana at age 12. And it's of some concern with the Kentucky case. And I'm not sure what it means to be highly motivated, because what I haven't seen or heard is any counseling or any action to address what the issues are. Getting to a .195 is really high. That's over twice the limit and raises a lot of concerns. So frankly, because of the bond violations, I'm tempted to ask for a short jail sentence and an extended period of probation.
Thank you. I've just been handed liens, so give me just a moment while I look at that. I do see an offense arising in, looks like Madison County, for an operating motor vehicle under the influence of alcohol, drugs, etc. 0.08 aggravating circumstances as a first. Date of the offense is January 28th, 2017. Severity is a misdemeanor with no entry regarding the outcome of the case.
Ours has warrant highlighted from 2018.
You do have a warrant? That doesn't,
That's what it says.
okay. Mine, for some reason, doesn't show that, so I suppose it could depend on when they were run. Mr. Williamson, you do have the right to address the court prior to sentencing. Is there anything you'd like me to know?
Just that I was under the understanding that those fines are still taken care of
What fines?
from those previous ones.
The ones that I referenced, or the Kentucky case?
Yeah.
The Kentucky case? Had you dealt with that case?
Yes, sir.
And-
It was a $750 fine.
And what were you convicted of? The drunk driving? Do you know what the outstanding warrant is for?
My assumption is that I need to get paid like this person.
What,
This says fail to appear. And then, it says fail to appear.
so this is actually your second drunk driving conviction? You believe so? All right. Is there anything else you'd like me to know?
Trying to straighten stuff out. Got a job. I could be there a year next month.
That's at Burger King?
Yes, sir.
Okay. Anything else? So the way I read your assessment, and correct me at any point if I'm wrong on this, but the way I read your assessment is that you were drinking the night before. You wake up, realize that you left your glasses at home and you were driving home to get your glasses.
Yes.
And at that, what time of day or night were you stopped?
Around 2 p.m.
2 p.m.?
Yes, sir.
Had you drank anything that day?
Yes, sir.
So at 2 p.m., you were still a .195? At what point did you stop drinking?
I do not know. I know it was still dark.
And then you get released from jail and you drink beer before your arraignment. You're arrested on drunk driving, you're released. You drink beer that night or whenever,
Yes, sir.
and then you show up for your arraignment in court, and that's when I put the no alcohol provision on you.
Yes, sir.
And then at least at some point, you test positive again for alcohol after being placed on bond.
Yes, I have no explanation for that.
Okay.
I did not have anything since that.
And then you started using alcohol and marijuana at age of 12.
Well, and that might be a bit of a misunderstanding. That was just the first time I ever tried.
Okay.
It didn't start a regular thing.
When did you start using alcohol regularly?
Probably. Guess it would have been.
At the age of 22?
Yes.
Okay. And how about the marijuana?
Probably closer to 18.
Okay. And you quit that in 05 to get a job. How often were you using the marijuana?
Yeah, it got to a daily basis.
Okay. And then I also see one of the reasons you drink is to help with pain and to sleep. I have to admit that you're not the first one I've said this to, but the assessments baffle me at times because with your history and what you report, as Ms. Carey said, to come back with a mild disorder doesn't compute. I mean, you are driving a motor vehicle, albeit probably not very well if there's a B on the lookout for you, but you're operating at a 0.195 and a 0.194. And that's after having been out drinking and at 2 o'clock in the afternoon. And it comes back as mild. So there's a few ways you can test. One is to have no disorder at all. And there's mild, moderate, and severe. And so when I put all these things together to see you come in as a mild, kind of shocks me. But I'm not the one who does the assessments. The assessments are provided to me and we leave that to the experts. What are your thoughts about probation?
You like to do good on it?
Have you been on probation before?
As a minor. Maybe one short period after that.
Were you successful with that?
Yes, sir.
I know we've kind of had a back and forth. Does that raise anything else you'd like me to know before I impose sentence?
Just as I said, I'm really working hard on getting things turned around, and I've had the same job for over a year. And they seem to like me a lot better. She tends to call me in a lot when they need somebody.
Okay. One day, 2 days credit. And I know in cases such as this, the legislature tells us that we start out with a presumption, albeit a rebuttable presumption, that there be no jail and no probation. I think the court placing the defendant on probation, I think, is warranted in this case for a few different reasons, as we've already discussed. His level of intoxication, the fact that he was at that level at 2 o'clock in the afternoon after having stopped drinking several hours before, the fact that he was operating a motor vehicle at that level, the fact that he has tested positive for alcohol while on bond, and the fact that he had missed tests while on bond, I believe provides the court with reasonable grounds to place the defendant on probation. As such, I'm going to place the defendant on probation for a period of 12 months. During that time, you're not to violate any law. Report is ordered, not leave the state of Michigan without the consent of your probation officer, and keep your contact and employment information current. This charge does allow you to be released early. So if you've done everything that we need you to do at the halfway point, you can be released at that point. If your probation officer feels as though that you should not be terminated, but you feel as though you should, you can petition the court on your own and we'll have a hearing and I'll make that determination. During the time you're on probation, you are to attend the alcohol highway safety education class, the victim impact panel. No alcohol, no illegal drugs, including recreational marijuana. I don't want you trading one substance for another. You'll be subject to testing pursuant to the terms of your probation officer. You are to follow the substance use assessment recommendations. No bars where the primary source of business is the sale of alcohol. Restaurants that serve it are fine, just no bars. No alcohol or illegal drugs where you reside. Technically, because this is a second, by your own statements, the court could sentence you to a recovery program. I'm not going to do that because we don't have anything in our records showing that you were truly convicted of that, but it could be something that you might want to consider. I'm going to order any counseling that your probation officer determines appropriate, including drug and alcohol counseling, and any other programming that she feels as though appropriate. There is a $75 crime victims' rights fee, a $50 state minimum fee, $150 fine, $150 court costs, and $150 attorney fee. To be on probation for 6 months is $180. There's also 2 days jail with 2 days credit. Because I have sentenced you to a term of incarceration, even though it's time served, you do have the right to appeal that decision. If you decided that you wanted to appeal that decision and could not afford an attorney to assist you, you have 14 days from today's date to request an attorney. Additionally, any balance that remains unpaid for more than 56 days will have a 20% penalty assessed to that by operation of law. Do you have any questions for me about your sentence?
The silver link and the random, do I still have to do that?
That ends today. And then you'll be subject to what your probation officer feels as though appropriate.
Okay, and also, shouldn't that be, if I was in for 4 days?
We'll double check that. It looks like you were arrested the 9th and I arraigned you on the 11th. Posted bond on, looks like the 11th. So the 10th?
Can I have the file?
Yep.
Yeah.
Yeah, the receipt's dated the 11th, so.
You signed the 10th.
So he was
in
released
jail
the
2
10th.
separate times, but then of course we don't count both in and out days, so he got a day for each time. So
Yeah,
2 days.
so it's 2 days.
He was in jail 2 separate times.
Well, for the bond violation and for the.
Oh,
initial.
okay.
And so that's probably where the 4 comes from.
So he has
Okay.
1 day from the initial
Mhm.
arrest and 1 day for the violation. All right. Any other questions? All right. I'll need you to go out to the front window where you checked in, get a copy of your judgment, make a payment if you're able to. If not, get set up on a payment plan and then go downstairs and get signed up for probation. All right. Good luck.
All right, let's talk about that. Judge Middleton's docket here was a full ride, from traffic tickets to retail theft to bond violations that hinted at much bigger problems down the road. Ed on a lighter, almost humorous note with Randall Fisher, pulled over at 4 a.m. not far from the judge's own house, blowing a .05. Middleton couldn't resist pointing out the time and place, telling him not to drive drinking near my house again at 4 a.m. With a wink of dry humor, he suggested the case might resolve as a civil infraction and sent Fisher back to work with a new date. Next up came 2 unlicensed driver cases, both treated with a mix of firmness and patience. Giselle Gonzalez, caught driving without a license on the 4th of July, explained she'd just gotten a job and was working on her permit. Middleton drilled down. Had she actually gone to the SOS yet? She admitted she'd postponed her test due to orientation, but promised to get it done. He gave her one more shot, telling her progress might win some leniency. Similarly, Kiana Hope's permit had expired, but with a new test booked for September, she too got another chance. with the gentle reminder that the court expected results, not promises. The tone shifted with William Dott, facing a fourth habitual offender enhancement for possessing Suboxone. On paper, it carried up to 15 years, but the deal reduced it to a misdemeanor for use without a prescription. Dott candidly admitted he'd been buying it off the street during chemo because he didn't want morphine or Norco, and now he was on a legitimate maintenance program in jail. Middleton acknowledged the reality. Suboxone often plays a role in managing addiction, credited him with 15 days, imposed the standard costs, and left the heavier issues for another judge. Alicia Sanchez Wilson returned to court for disturbing the peace after a parking lot fight where she blew a 190. Middleton's patience was thin. He pointed out unpaid fines from earlier cases and warned her directly, "I'm trying not to put you in jail. Don't talk yourself into it." He stacked on costs and made it clear that failure to pay next time could land her behind bars. Rebecca Nickerson's retail fraud plea was a study in muddled excuses. Walmart staff claimed she walked out with 8 unpaid items: oil, nail polish, figurines, and bags. She pushed back, saying multiple employees had checked her cart, but Middleton wasn't buying it. He barred her from Walmart for a year, ordered restitution and fees, and quipped dryly, "I don't really like being Walmart's collection agency, but that's what I do." The heaviest moment came with Deontay Williams. Already on bond for assaulting Ava Calvin, he admitted to violating conditions by being in her apartment complex laundry room. He claimed he was just doing laundry, denied knowing about a PPO, and even suggested Calvin had been contacting him. Middleton wasn't swayed. He gave him 5 consecutive days on the bond violation and warned that prosecutors take new charges while on bond extremely seriously, especially with fresh allegations of home invasion and strangulation looming. The atmosphere across the docket swung from light banter to real gravity. Middleton's style was on